All right, guys, we are back for section 14, which is all about legal issues in digital forensics. Here's our funny internet picture of the day. Okay, everybody loves cats, right? The Fourth Amendment to the United States. This might be the most complex amendment of all of them, and I would bet, although I don't know for a fact, I would bet that it has the most Supreme Court cases dedicated to it, with the possible exception of the First Amendment. But the Fourth Amendment basically says that the people are protected from unreasonable search and seizure, and that warrant requirements are, we'll talk about later. So, one of the, if not the most important Fourth Amendment Supreme Court case is a case called Katz v. U.S. from 1967. And essentially, this is where we defined what that word unreasonable search and seizure means. Because remember, it just says search and seizure of a person's papers, houses, persons, and effects. Right? So what exactly does that mean? And prior to 1967, essentially, if the police or whatever law enforcement agency you're talking about did not physically touch your person, house, papers, or effects, it wasn't a Fourth Amendment violation. But in Katz, essentially the facts of the case are this guy was a gambler, and he would go to a payphone and call up, whoever took his bets and would say, I want to bet such and such amount on such and such team, and hang, that. So lots of people knew he was making these phone calls, and those were illegal, but he did them anyway. And the FBI decided that it was going to bust this guy. So without a warrant, they put a recording device in the phone booth. And very soon after, Katz goes into the phone booth, shuts the door, which is important, takes the phone, calls his contact, and says, yeah, I want to bet $500 on such and such team to win. Opens the door and leaves. And the FBI recorded that conversation. Now, Katz appealed all the way up to the Supreme Court, saying that the police didn't have a warrant to record that conversation. Police said, look, we didn't touch his person, we didn't touch his house, we didn't touch his papers, we didn't touch his effects. We didn't need a warrant. Supreme Court said, no, we're not doing that anymore. We're going to change how we view this whole Fourth Amendment thing. And what they said in their decision was essentially the Fourth Amendment applies, and thus the police need a warrant anytime a person has a reasonable expectation of privacy. Because Katz shut the door of the phone booth, that was one thing to indicate that he had an expectation that his conversation was going to remain private. As such, if the FBI wanted to record it, they needed a warrant, because the Fourth Amendment applies anytime there is a reasonable expectation of privacy. Okay? So that's kind of the basic theory behind the Fourth Amendment and when warrants are required and when they're not, and has been since. And of course, there are further Supreme Court cases that redefine all kinds of stuff on exactly what's reasonable, exactly what's not. But that's maybe the most important currently still standing decision for Fourth Amendment Supreme Court decisions. When it comes to a warrant, warrants need to be signed by a neutral magistrate, which in most cases means a judge who's not personally connected to the case in any way. They need to be based on probable cause, which has never really strictly been defined, but it's a higher standard than just a reasonable suspicion, but it's a much lower standard than beyond any reasonable doubt, right? So you just need kind of, yeah, there's probably a crime that has been or is being committed. This person probably is the one doing it, and there's probably some evidence at such and such a place, okay? So a neutral magistrate needs to sign it. It needs to be based on probable cause, and it needs to particularly describe the location to be searched and the things to be seized. Okay, so if I'm doing a warrant for a guy who I think has a bunch of child porn on his computer. The location to be searched is probably going to be his house, right? So I'm going to particularly describe his house, which means not just the street address, but the apartment number if there is one, a description, a picture, right? As particular as I can possibly get. Like, you cannot be too particular in this case. Give the street address, print out a copy of Google Maps showing exactly, top-down satellite view, picture of the front of the house, description of the house, all that stuff. Then the things to be seized. If it's a child porn investigation, I don't want to just say any child porn. That's way too broad, but also not broad enough in that how do I know there's child porn on there or not if it's a digital file? So things to be seized, I'm going to say any computers, any mobile devices that can store digital data, any cell phones, any laptops, any USB flash drives, any CDs or DVDs that I think might have non-commercial content on them. And I'm going to list all those things. Any place where digital data might have been stored by this bad guy who I think has child porn on it. So that's the requirements for a warrant. Most of the time, this probable cause is established through an affidavit, where essentially the law enforcement officer who wants the warrant will contact the neutral magistrate and will write out, it's usually written, although sometimes it can be verbal, this affidavit that says, I believe that such and such location has such and such a thing, and my probable cause is that, an undercover informant told me this, or I personally witnessed that, or the evidence from this network investigation shows that, where does that probable cause come from? The law enforcement officer applying for the warrant needs to write out, with as much detail as possible, exactly what their probable cause is for that warrant. Then the neutral magistrate judges it. He determines whether probable cause exists. He determines whether the location to be searched is specific enough, determines whether the things to be seized are specific enough, and if all those things are a yes, he or she signs the warrant, and then the law enforcement officer can execute it. Okay? But that is very, very, that process can take time. And a lot of times, the law enforcement officers either don't have that kind of time or they don't want to spend that kind of time. And thus, there are a bunch of ways around the warrant requirement. So just because somebody has a reasonable expectation of privacy in something doesn't necessarily mean the law enforcement officer has to get a warrant. There are a bunch of exceptions to that have been carved out in different Supreme Court cases, okay? By far the most common exception to the Fourth Amendment warrant requirement is consent. Somebody who has control over that thing to be searched or the thing to be seized gives their consent to the law enforcement, says, yeah, please, go ahead, search through my computer. So if I'm the victim of a hacking attack, I'm not going to make law enforcement get a warrant to see the contents of my computer. Why would I? I'm just going to give them my consent to search it, even though I have a reasonable expectation of privacy in the contents of my computer. In this case, I'm the victim. I want them to find evidence. So I'm just going to say, yes, please, search my computer. I don't want you to spend the time and energy going to get a warrant if I just want you to do it. What's difficult sometimes is who has the authority to give consent. So this computer is my computer. Obviously, I have authority to give consent. But does my wife? Does my roommate, if I had a roommate? Does my landlord? Right? And essentially what they've said is, if to be able to give consent to search a place or a thing, the person giving the consent has to have authority over that place or thing. So let's take the example where there's a 2-bedroom apartment, 2 roommates. One roommate lives in each bedroom, but there's a shared living room, shared kitchen, shared bathroom. Okay? The police knock on the door, and the roommate, who is actually the suspect that they're searching for evidence against, is not home. But the second roommate, who is not at all a suspect, is home. Police can say, hey, can we search the premises? That roommate is allowed to give consent to search any areas of the house that he or she has common authority over. And in my example, that would be the living room, the kitchen, and the bathroom. But they would not have authority to give police consent to search the other roommate's bedroom, because the second roommate doesn't have the authority to give access or give consent to search that room, because that's not their room. That is not a shared room. That is the other person's room. There was a court case applying this to computers. There was a case called US v. Smith. There was a computer in the family room of a house. Police went in. The husband of the family wasn't home, so they asked the wife, hey, can we search your computer? She gave consent. They searched the computer and found, I think it was child porn, but some kind of incriminating evidence. But they didn't have a warrant. But they didn't need a warrant because they had the consent of the owner. The husband, on trial for having this child porn, appealed his conviction because it was his computer, he argued, and not his wife's computer, so his wife's computer couldn't give consent to search it. Supreme Court looked at the facts of the case. The facts of the case were the computer was in a family room. There were no individualized user accounts. So like the husband had his own account, the wife had her own account, the kids had their own accounts. None of that existed. It was just one user account on the computer. Everybody was allowed to use it. The kids used it, the wife used it, and as such, the wife had authority over that device and was perfectly capable of giving her consent to law enforcement to search the contents of that computer. Okay? With my computer, my wife comes up here and plays video games on it all the time. So a court would probably rule that she has the authority over this computer, even though it's my computer that I paid for in my office. The fact that she comes up here and uses it commonly probably means that a judge would say, no, she had common authority over that computer. She can give consent to the police to search it. Second exception to the Fourth Amendment is what's called plain view. And this is an incredibly complex concept. But the very, very basic version of it is, if a law enforcement officer is standing in a place where he or she is allowed to be, and they look over and they see something that is obviously illegal or obviously some kind of evidence of a crime, that does not count as a search. They didn't need a warrant to find that evidence and seize that evidence and arrest the person. So if a police officer pulls a car over, legal stop. They were speeding. He clocked them speeding. He pulls them over, walks up to the window, looks in, says, hey, can I see your license and registration? And then he glances in the back seat through the window and sees a kilo of cocaine. That is obviously illegal. Him looking through that window does not count as a search, and he didn't need a warrant to do it. Okay? And again, this gets really complicated really fast, but that's the very simple version. So if a police officer is standing behind you as you're on a computer and you bring up a bunch of child porn and he looks over and is like, oh, look, that's child porn. That is not a search. He did not need a warrant to do that, as long as he was behind you for legal reasons, right? Search incident to arrest. Essentially, if you get arrested, the police are allowed to search you and anything within your reach, which is not really well defined, for any kind of contraband or evidence or weapons or anything like that. So you get put into handcuffs, the police are going to search you, they're going to search your pockets, they're going to take everything out, they're going to, if you have a backpack on you, they're going to search the backpack. It's called a search incident to arrest. There was a major case not too long ago called Riley v. California. And essentially, prior to 2014, police officers, when they arrested somebody, were taking their cell phone and then looking through the contents of the cell phone for evidence without a warrant as part of that search incident to arrest. In Riley v. California, the person appealed all the way up to the Supreme Court and said, look, the purpose of a search incident to arrest is to find contraband that we don't want people bringing into jails, weapons, tools that can be used for escape, stuff like that. The digital contents of a cell phone, it's none of those things. Thus, the search incident to arrest does not cover the contents the digital contents of a cell phone. And the Supreme Court agreed. So since 2014, if police are allowed to seize your phone, absolutely. But if they want to look at the contents of your cell phone after they arrest you, they need to apply for and get a warrant or have one of these other exceptions to the warrant requirement, okay? Vehicle searches, essentially, again, this gets really complicated really fast, but people have less of a expectation of privacy in a vehicle on public roads. Because vehicles are, use public roads paid for by tax dollars. Essentially, the Supreme Court has said you have less of a Fourth Amendment protection in cars than you do in, say, your house. Not zero. Police can't search your car anytime they want. But it is easier for them to search a car than it would be to, say, search a house. In border areas, essentially, if you're at the border, the Fourth Amendment doesn't apply. If I come across from Mexico to the United States, law enforcement is perfectly allowed to search anything I have on me with zero reasonable suspicion, probable cause, anything. They can just be like, oh, hey, you want to come into our country? I'm searching all your bags. If you've ever flown out of the country, when you come back, you have to go through customs. And one of the things customs usually does is unpack all your luggage and look through all your luggage and make sure you're not bringing anything into the country that you shouldn't be, drugs or porn or whatever. And they don't need a warrant for that because it's a border area. And international airports count as a border area in this for purposes of this. And there's a lot of digital evidence that gets seized at the border. People bringing in all kinds of different illegal digital stuff, whether it's child porn or hacking tools or, all kinds of different digital evidence are seized at the border. Anything shared with a third party, the original person no longer has a reasonable expectation of privacy, right? So up until recently, this meant that everything except the contents of a phone call was revealed by you to the phone company. So the phone number you dialed, how long the call lasted, things like that kind of metadata, not what you said during the call, but how long the call lasted, what the phone number was, how many times you called that phone number over the course of the last month, all that stuff. You had no reasonable expectation of privacy with that data because you shared it with the phone company, who is a third party, which means you no longer have a reasonable expectation of privacy for it. So the police don't need a warrant to request that information from the phone company. If they want the contents of your call, if they want what you actually said, you have a reasonable expectation of privacy. But that other data, who you called, how long the call lasted, all those things, you shared with the phone company, thus no reasonable expectation of privacy, thus no warrant required. The Supreme Court has cut down on that a little bit since, but essentially if you share information with a third party, the police can go ask that third party for the information, and you no longer have a reasonable expectation of privacy in it. They don't need a warrant to get that information from the third party you shared it with. Okay? And then there's exigent circumstances, which essentially means if the police wait to get a warrant, somebody's going to get hurt, or evidence is going to get destroyed, or something bad is going to happen. So kind of the common movie and television trope is that two police officers are standing outside a house or an apartment or whatever, and they're like, I hear a baby crying. Do you hear a baby crying? Or, oh, I hear a woman screaming. Do you? Yeah, okay. And then they go in. The purpose of that is to establish these exigent circumstances, i.e. They had to go in to the door of the house or the apartment, whatever, because somebody was being hurt and they needed to stop it. They didn't have time to apply for a warrant. So exigent circumstances can be used with digital evidence. So police can seize different digital types of digital storage media if they have a reasonable belief that not seizing it right then and there will result in it being deleted or destroyed or some other kind of thing. All right, when I come back, in the next subsection, we're going to talk about the Fifth Amendment and the federal rules of evidence.